Question 1. What factors determine an individual's eligibility to apply for and obtain a restricted possession and acquisition license, RPAL, in Canada, considering the legal framework governing firearms ownership? Option A. Completing a basic firearms safety course and having a friend vouch for their character. Option B. Successful completion of the Canadian Firearms Safety Course, CFSC, and the Canadian Restricted Firearms Safety Course, CRFSC, passing a comprehensive background check, providing satisfactory references, and demonstrating a lawful purpose for acquiring restricted firearms. Option C. Attending a firearms safety course and having a general interest in sport shooting. Option D. Being a member of a recognized shooting club and having a clean criminal record. The correct answer is B. Successful completion of the Canadian Firearms Safety Course, CFSC, and the Canadian Restricted Firearms Safety Course, CRFSC, passing a comprehensive background check, providing satisfactory references, and demonstrating a lawful purpose for acquiring restricted firearms. Explanation. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for obtaining a restricted possession and acquisition license, RPAL, in Canada, which involves demonstrating both eligibility and the safe handling of restricted firearms. The applicant must understand that the process is not merely about expressing interest, but about meeting stringent legal criteria set by the Canadian Firearms Program. Careful judgment is required to ensure all documentation is accurate, and all prerequisites are met to avoid unnecessary delays or outright refusal. The best professional practice involves a thorough understanding and adherence to the requirements outlined in the Firearms Act Canada and its associated regulations. This includes completing the Canadian Firearms Safety Course, CFSC, and the Canadian Restricted Firearms Safety Course, CRFSC, passing background checks, providing references, and demonstrating a genuine reason for acquiring a restricted firearm. The applicant must proactively gather all necessary documentation, including proof of course completion and references who can attest to their suitability, and submit a complete application to the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program. This approach ensures compliance with all legal obligations and demonstrates the applicant's commitment to responsible firearm ownership. An incorrect approach would be to assume that simply attending a firearms safety course is sufficient without completing the full application process or understanding the specific requirements for restricted firearms. This fails to acknowledge the legal obligation to formally apply and be approved by the authorities before possessing or acquiring such firearms. Another incorrect approach would be to rely on informal assurances from friends or family about their suitability without understanding the formal reference requirements stipulated by the RCMP. This bypasses a critical part of the vetting process designed to ensure public safety. Finally, attempting to acquire a restricted firearm without a license, even if a course has been completed, is a direct contravention of Canadian law and carries severe penalties. Professionals should approach this by first consulting the official resources provided by the Canadian government regarding firearms licensing. They should then systematically address each requirement, ensuring all documentation is accurate and complete before submission. If unsure about any aspect of the process, seeking clarification from the RCMP Canadian Firearms Program or a qualified legal professional specializing in firearms law is advisable. Question 2. Compliance review shows a firearms owner in Ontario is preparing to transfer a restricted firearm to a friend. What is the most appropriate and legally compliant method for the owner to proceed with this transfer under Canadian federal law? Option A. Verify the friend possesses a valid restricted possession and acquisition license, RPAL, and confirm the firearm is registered to the owner before initiating any transfer steps. Option B. Transfer the firearm to the friend immediately, assuming it is registered to the owner, and address the formal transfer documentation afterwards. Option C. Accept the friend's verbal assurance that they hold a valid RPAL and proceed with the transfer, intending to complete the paperwork later. Option D. Hand over the firearm to the friend and instruct them to apply for an RPAL and registration after taking possession. Correct answer is A. Verify the friend possesses a valid restricted possession and acquisition license, RPAL, and confirm the firearm is registered to the owner before initiating any transfer steps. Explanation. Scenario analysis. This scenario presents a professional challenge due to the critical nature of firearm safety and the legal obligations associated with restricted possession and acquisition licenses, RPAL, in Canada. Misinterpreting or failing to adhere to the specific requirements for transferring a restricted firearm can lead to serious legal consequences for both the transferor and the transferee, including potential criminal charges and the revocation of licenses. Careful judgment is required to ensure all regulatory steps are followed precisely. Correct approach analysis. The best professional practice involves meticulously verifying the transferee's valid RPAL and ensuring the firearm is registered to the transferor before initiating the transfer process. This approach directly aligns with the requirements of the Canadian Firearms Act and its associated regulations, which mandate that a restricted firearm can only be transferred to an individual who holds a valid RPAL, and that the firearm itself must be properly registered. This ensures that the transfer is legal, safe, and compliant with all federal laws, protecting both parties and public safety. Incorrect approaches analysis. One incorrect approach involves proceeding with the transfer based solely on the transferee's verbal assurance of possessing a valid RPAL. This fails to meet the legal requirement for documented verification and exposes the transferor to significant legal risk if the transferee does not, in fact, hold a valid license or if the firearm is not properly registered. This approach disregards the due diligence mandated by law. Another incorrect approach is to transfer the firearm without confirming its registration to the transferor, relying on the assumption that it is registered. This bypasses a fundamental requirement of the Canadian Firearms Act, which stipulates that only registered firearms can be legally transferred. Failure to confirm registration can result in the illegal transfer of an unregistered firearm, a serious offense. A further incorrect approach is to delay the formal transfer process until after the firearm has been physically handed over to the transferee. This is a direct contravention of the law, as possession of a restricted firearm by an unlicensed individual or a firearm not properly transferred is illegal. This approach prioritizes convenience over legal compliance and safety. Professional reasoning. Professionals in this situation should adopt a systematic approach. First, they must be thoroughly familiar with the Canadian Firearms Act and its regulations pertaining to restricted firearms. Second, they should always prioritize obtaining and verifying all required documentation, such as the transferee's RPAL, before any physical transfer occurs. Third, they must confirm the registration status of the firearm with the relevant authorities. Finally, they should maintain clear records of the transfer process, including all documentation exchanged, to demonstrate compliance. This structured decision-making process ensures adherence to legal obligations and upholds professional standards of safety and responsibility. Question 3. Benchmark analysis indicates that an applicant in Ontario is seeking to transfer a restricted firearm that was legally acquired prior to a recent change in its classification. The applicant holds a valid restricted possession and acquisition license RPAL and has the original acquisition permit. What is the most appropriate course of action to ensure compliance with Canadian federal and Ontario provincial firearms regulations for the transfer? Option A. Proceed with the transfer using the original acquisition permit and the applicant's current RPAL, assuming the previous registration is sufficient. Option B. Contact the Ontario Chief Firearms Officer, CFO, to inquire about the specific documentation and procedures required for transferring a restricted firearm whose classification has recently changed. Option C. Rely on the seller's assurance that the transfer process remains unchanged and complete the transaction without further verification. Option D. Attempt to reclassify the firearm as non-restricted through informal channels before proceeding with the transfer. The correct answer is B. Contact the Ontario Chief Firearms Officer, CFO, to inquire about the specific documentation and procedures required for transferring a restricted firearm whose classification has recently changed. Explanation. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements of the Canadian Firearms Act concerning restricted firearms, particularly when dealing with a firearm that has been legally acquired but is now subject to new regulations or a change in its classification. The applicant must demonstrate a thorough understanding of the legal framework governing the possession and acquisition of restricted firearms in Canada, ensuring compliance with all applicable provincial and federal laws. Careful judgment is required to interpret the regulations accurately and to provide the necessary documentation to the Chief Firearms Officer, CFO. The correct approach involves proactively seeking clarification from the relevant provincial CFO regarding the specific documentation required for the transfer of the restricted firearm, given the change in its classification. This approach is correct because it directly addresses the regulatory requirement for the CFO to approve the transfer of restricted firearms. By contacting the CFO, the applicant ensures they are following the prescribed legal pathway for transferring ownership of a restricted firearm, which is mandated by the Firearms Act and its associated regulations in Canada. This proactive communication demonstrates due diligence and a commitment to legal compliance. An incorrect approach would be to assume that the previous registration and acquisition permit are sufficient for the transfer without verifying current requirements. This is incorrect because regulatory landscapes can change, and a firearms classification or the transfer process might be subject to updated rules. Failing to confirm with the CFO could lead to an invalid transfer, potential legal repercussions, and the denial of the RPAL application. Another incorrect approach would be to proceed with the transfer based solely on the seller's assurance that the process is straightforward. This is incorrect because the responsibility for ensuring legal compliance rests with the applicant. Relying on informal assurances without official confirmation from the regulatory authority is a significant ethical and legal failing, as it bypasses the established oversight mechanisms designed to ensure public safety and prevent the illegal acquisition of firearms. A further incorrect approach would be to attempt to register the firearm as non-restricted without proper authorization or a formal reclassification process. This is incorrect because it constitutes a deliberate attempt to circumvent the legal framework for restricted firearms. Such an action would be a direct violation of the Firearms Act and would undoubtedly lead to the denial of the RPAL application and potential criminal charges. Professionals should employ a decision-making framework that prioritizes understanding and adhering to the specific legal and regulatory requirements of the jurisdiction. This involves identifying the relevant governing bodies, in this case, the provincial CFO, consulting official documentation, and proactively seeking clarification when faced with ambiguity or changes in regulations. The process should always involve verifying information through official channels rather than relying on assumptions or informal advice. Question 4. Benchmark analysis indicates that a restricted possession and acquisition license, RPAL, holder in Ontario, Canada, is contemplating the acquisition of a firearm classified as prohibited under Canadian law. Considering the stringent regulatory environment, which of the following actions represents the most prudent and legally compliant approach to this situation? Option A. Acquire the firearm based on the belief that its age or historical significance exempts it from current prohibitions without verifying specific legal exemptions. Option B. Assume that possessing an RPAL and ensuring the firearm is registered will automatically legitimize the acquisition of any firearm, including prohibited ones. Option C. Diligently research and confirm the specific legal provisions and any applicable exemptions under the Firearms Act, Canada, and its regulations that would permit the acquisition of this particular prohibited firearm, ensuring all conditions are met before proceeding. Option D. Proceed with the acquisition based on informal advice from other firearm enthusiasts or online discussions about the firearm's collectability. The correct answer is C. Diligently research and confirm the specific legal provisions and any applicable exemptions under the Firearms Act, Canada, and its regulations that would permit the acquisition of this particular prohibited firearm, ensuring all conditions are met before proceeding. Explanation. Scenario analysis. This scenario presents a professional challenge for a restricted possession and acquisition license, RPAL, holder in Ontario, Canada, who is considering acquiring a prohibited firearm. The challenge lies in navigating the complex and stringent regulation surrounding prohibited firearms, ensuring full compliance with the Firearms Act, Canada, and its associated regulations, and understanding the specific conditions under which such acquisitions might be permissible, if at all. Misinterpreting or overlooking these regulations can lead to severe legal consequences, including license revocation and criminal charges. Careful judgment is required to distinguish between legal acquisition pathways and prohibited actions. Correct approach analysis. The best professional practice involves diligently researching and understanding the specific conditions under which a prohibited firearm can be legally acquired in Ontario, as defined by the Firearms Act, Canada, and its regulations. This includes verifying if the firearm is subject to a specific exemption, such as being a grandfathered firearm with specific registration requirements, or if the acquisition is for a purpose permitted under strict conditions, like approved museum display or scientific research, which typically requires specific authorizations beyond a standard RPAL. The individual must confirm that they meet all eligibility criteria and possess the necessary authorizations or permits before attempting any acquisition. This approach prioritizes absolute adherence to the law and ensures that any acquisition is conducted through a legally recognized channel, thereby upholding the integrity of their RPAL and avoiding any contravention of Canadian firearms law. Incorrect approaches analysis. One incorrect approach involves assuming that simply possessing an RPAL automatically grants the right to acquire any firearm, including prohibited ones, provided it is registered. This is a fundamental misunderstanding of Canadian firearms law. Prohibited firearms have very limited acquisition pathways, and mere registration does not legitimize an otherwise illegal acquisition. This approach fails to recognize the distinct categories of firearms and the specific prohibitions and exemptions associated with them. Another incorrect approach is to rely on informal advice from other firearm owners or online forums regarding the acquisition of prohibited firearms. While peer advice can sometimes be helpful for common firearms, it is highly unreliable and potentially dangerous when dealing with prohibited items. The legal framework is precise, and informal interpretations can easily lead to violations. This approach bypasses the official regulatory channels and exposes the individual to significant legal risk. A third incorrect approach is to proceed with the acquisition based on a belief that the firearm is old or collectible, implying it might be exempt from current regulations. While certain historical firearms may have specific provisions, the classification of a firearm as prohibited is determined by its characteristics and the current legislation, not solely by its age or perceived collectability. Without explicit confirmation of a specific exemption under the Firearms Act, Canada, and its regulations, assuming exemption is a serious regulatory failure. Professional reasoning. Professionals in regulated fields must always prioritize official sources of information and adhere strictly to the governing legislation. When considering actions that fall into complex or restricted categories, such as acquiring prohibited firearms, the decision-making process should involve 1. Identifying the specific regulation or law that governs the action, in this case, the Firearms Act, Canada, and its regulations. 2. Consulting official government resources or legal counsel for definitive interpretation. 3. Verifying all eligibility requirements and necessary permits or authorizations. 4. Acting only when absolute certainty of legal compliance is established. Relying on informal advice or assumptions is never a substitute for diligent legal research and adherence to regulatory frameworks. Question 5. Benchmark analysis indicates that an individual in Ontario holding a restricted possession and acquisition license, RPAL, is interested in acquiring a firearm that is classified as prohibited under Canadian federal law. Considering the regulatory framework for firearms in Ontario and Canada, which of the following actions represents the most prudent and legally compliant approach for the RPAL holder? Option A. Conduct thorough research into the specific classification of the firearm under the Criminal Code of Canada and investigate any applicable exemptions or grandfathering provisions that might permit its acquisition by an RPAL holder in Ontario. Option B. Assume that because they hold an RPAL, they are permitted to acquire any firearm, including prohibited ones, as long as the seller is legally compliant. Option C. Rely on advice from experienced firearm enthusiasts and online forums to determine the legality of acquiring the prohibited firearm. Option D. Proceed with the acquisition if the seller confirms they legally own the firearm prior to any potential prohibition changes. The correct answer is A. Conduct thorough research into the specific classification of the firearm under the Criminal Code of Canada and investigate any applicable exemptions or grandfathering provisions that might permit its acquisition by an RPAL holder in Ontario. Explanation. Scenario analysis. This scenario presents a professional challenge for a restricted possession and acquisition license, RPAL, holder in Ontario who is considering acquiring a prohibited firearm. The challenge lies in navigating the complex and evolving legal landscape surrounding prohibited firearms, ensuring full compliance with the Criminal Code of Canada and any relevant provincial regulations, and understanding the specific conditions under which such acquisitions might be permissible, if at all. Misinterpreting or failing to adhere to these regulations can lead to severe legal consequences, including license revocation and criminal charges. Careful judgment is required to distinguish between legal acquisition pathways and prohibited activities. Correct approach analysis. The best professional practice involves a thorough and documented investigation into the specific legal status of the firearm in question under current Canadian federal law, specifically the Criminal Code of Canada, and any applicable Ontario provincial legislation or regulations. This includes verifying if the firearm is classified as prohibited, and if so, determining if any specific exemptions or grandfathering provisions apply that would permit its acquisition by an RPAL holder. This approach is correct because it prioritizes strict adherence to the law as the primary determinant of action. The Criminal Code of Canada, particularly sections related to prohibited firearms and their acquisition, is the ultimate authority. Any acquisition must be demonstrably legal under these provisions. This proactive due diligence ensures that the RPAL holder is acting within the bounds of the law, protecting themselves from legal jeopardy, and upholding their responsibilities as a license holder. Incorrect approaches analysis. One incorrect approach involves assuming that simply possessing an RPAL automatically grants the right to acquire any firearm, including those that are prohibited. This is a fundamental misunderstanding of the licensing system, which is designed to regulate the possession and acquisition of non-prohibited and restricted firearms, with strict controls and often specific authorizations required for prohibited firearms. This approach fails to recognize that the RPAL is a prerequisite for acquiring certain classes of firearms, but it does not override specific prohibitions. Another incorrect approach is to rely on informal advice from other firearm owners or online forums, without independently verifying the legality through official sources. While peer advice can sometimes be helpful, it is not a substitute for legal expertise or direct consultation with the relevant authorities. The legal status of firearms can change, and interpretations of the law can vary. Relying on unverified information can lead to serious legal missteps. This approach is ethically and legally flawed as it outsources critical legal responsibility. A further incorrect approach is to proceed with the acquisition based on the belief that if the firearm was legally owned by the seller, it can be legally transferred to the buyer. While the seller's legal ownership is a factor, it does not automatically legitimize a transfer if the firearm itself is prohibited, and no specific exemption applies to the intended acquisition. The focus must be on the legality of the acquisition by the RPAL holder, not solely on the seller's prior legal possession. This approach overlooks the specific regulations governing the transfer and acquisition of prohibited firearms. Professional reasoning. Professionals in this situation should adopt a risk-averse and legally compliant decision-making framework. This involves 1. Identifying the specific firearm and its classification under Canadian federal law. 2. Consulting the most current version of the Criminal Code of Canada and any relevant provincial regulations pertaining to firearms acquisition. 3. If the firearm is classified as prohibited, researching any specific exemptions, authorizations to carry, or grandfathering provisions that might apply to its acquisition by an RPAL holder. 4. If there is any ambiguity or uncertainty, seeking clarification directly from the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program, or a legal professional specializing in firearms law in Ontario. 5. Documenting all research, communications, and decisions made. The guiding principle must always be strict adherence to the law, prioritizing legal compliance over convenience or assumption. Question 6. Benchmark analysis indicates that an individual in Ontario who holds a restricted possession and acquisition license, RPAL, has recently inherited a property and discovered a firearm that is not listed on any registry and for which they have no documentation. What is the most appropriate and legally compliant course of action for this RPAL holder? Option A. Dispose of the firearm privately by selling it to a known collector or discarding it to avoid legal complications. Option B. Store the unregistered firearm securely on their property and plan to address its registration or disposal at a later, more convenient time. Option C. Attempt to register the firearm directly through the Provincial Firearms Registry without prior notification to the authorities about its discovery. Option D. Immediately contact the local police service or the RCMP Canadian Firearms Program to report the discovery of the unregistered firearm. The correct answer is D. Immediately contact the local police service or the RCMP Canadian Firearms Program to report the discovery of the unregistered firearm. Explanation. Scenario analysis. This scenario presents a professional challenge for a restricted possession and acquisition license, RPAL, holder in Ontario who discovers an unregistered firearm in their inherited property. The challenge lies in navigating the legal requirements for dealing with such a discovery, while ensuring compliance with the Firearms Act, Canada, and Ontario's provincial regulations concerning firearms. Failure to report or properly dispose of an unregistered firearm can lead to severe legal consequences, including criminal charges and the revocation of their RPAL. The individual must balance their personal situation with their legal obligations as a licensed firearm owner. Correct approach analysis. The best professional practice involves immediately contacting the local police service or the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program to report the discovery of the unregistered firearm. This approach is correct because Section 9 of the Criminal Code of Canada and the Firearms Act, Canada, mandate the reporting of unregistered firearms. By proactively informing the authorities, the RPAL holder demonstrates due diligence and adherence to legal obligations. This allows law enforcement to properly investigate, seize, and dispose of the firearm according to legal procedures, thereby mitigating any potential legal liability for the individual. This action aligns with the ethical responsibility of licensed firearm owners to uphold public safety and the integrity of the firearms regulatory system in Canada. Incorrect approach is analysis. One incorrect approach is to store the unregistered firearm without reporting it, intending to deal with it later. This is a direct contravention of Canadian firearms laws, specifically the requirement to report unregistered firearms, creates a significant legal risk for the RPAL holder, as possession of an unregistered firearm is an offense. Furthermore, it undermines public safety by allowing an unaccounted-for firearm to remain in circulation. Another incorrect approach is to attempt to register the firearm without first reporting its discovery to the authorities. While the intent might be to legitimize the firearm, bypassing the mandatory reporting procedure is illegal. The process for registering newly acquired firearms, especially those found unexpectedly, involves specific protocols that must be followed, and attempting to circumvent these can lead to penalties. A third incorrect approach is to dispose of the firearm privately without informing the authorities, such as by selling it or discarding it. This is highly illegal and dangerous. Selling an unregistered firearm is a serious criminal offense, and improper disposal could lead to the firearm falling into the wrong hands, posing a significant risk to public safety. It also prevents law enforcement from properly tracking and accounting for firearms. Professional reasoning. Professionals in possession of an RPAL must prioritize legal compliance and public safety. When faced with an unexpected discovery of an unregistered firearm, the decision-making process should involve 1. Immediately recognizing the legal obligation to report. 2. Consulting relevant legislation, Firearms Act, Criminal Code, and provincial guidelines. 3. Prioritizing contact with the appropriate law enforcement agency. 4. Avoiding any actions that could be construed as illegal possession or disposal. This systematic approach ensures that legal obligations are met and potential risks are minimized. Question 7. Benchmark analysis indicates that an individual in Ontario, Canada, wishes to acquire a restricted firearm. Which of the following approaches best aligns with the regulatory requirements for obtaining a restricted possession and acquisition license, RPAL, and subsequently acquiring the firearm? Option A. The applicant prepares a detailed written submission outlining the specific, lawful purpose for acquiring the restricted firearm, supported by any relevant documentation, and submits this along with their RPAL application. Option B. The applicant provides a vague reason for acquisition, such as for sport, without further elaboration or supporting evidence. Option C. The applicant proceeds with the acquisition of the restricted firearm immediately after submitting their RPAL application, assuming approval will be granted. Option D. The applicant submits their RPAL application with a brief statement indicating a general interest in firearms. The correct answer is A. The applicant prepares a detailed written submission outlining the specific, lawful purpose for acquiring the restricted firearm, supported by any relevant documentation, and submits this along with their RPAL application. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for acquiring restricted firearms in Ontario, Canada, while ensuring full compliance with the Firearms Act and its associated regulations. Misinterpreting or failing to adhere to these requirements can lead to significant delays, denial of the application, and potential legal repercussions. The onus is on the applicant to demonstrate they meet all eligibility criteria, including the necessity for the firearm. Correct approach analysis. The best professional practice involves the applicant meticulously gathering all required documentation, including a clear and compelling explanation of the genuine need for the specific restricted firearm, supported by evidence. This approach directly addresses the core requirement of demonstrating a lawful purpose for possessing a restricted firearm under Ontario's regulatory framework. The Firearms Act, specifically sections pertaining to the acquisition of restricted firearms, mandates that an applicant must satisfy the Chief Firearms Officer, CFO, of their eligibility, which includes demonstrating a valid reason for acquisition. Providing a well-documented and justifiable purpose is paramount to meeting this standard. Incorrect approaches analysis. Submitting an application without a detailed explanation of the genuine need for the restricted firearm is a significant regulatory failure. This approach neglects the fundamental requirement under the Firearms Act to justify the acquisition of such firearms, potentially leading to an automatic denial by the CFO. Providing a vague or generic reason for acquiring the restricted firearm, such as personal interest or collection, without further substantiation, is also professionally unacceptable. While personal interest may be a factor, it is rarely sufficient on its own to satisfy the CFO's requirement for a demonstrable lawful purpose, especially for restricted firearms. The regulations emphasize a specific, demonstrable need. Attempting to acquire the restricted firearm without first obtaining the necessary restricted possession and acquisition license, RPAL, is a direct contravention of the Firearms Act. The RPAL is a prerequisite for the possession and acquisition of restricted firearms in Ontario, and proceeding without it constitutes an illegal act. Professional reasoning. Professionals should approach RPAL applications by prioritizing thoroughness and adherence to regulatory mandates. This involves understanding the specific requirements of the Firearms Act and provincial regulations, meticulously preparing all necessary documentation, and clearly articulating the lawful purpose for the acquisition. A structured approach, starting with understanding the why behind the regulation, public safety, and responsible firearm ownership, then gathering supporting evidence, and finally submitting a complete and accurate application, is crucial for successful outcomes and maintaining professional integrity. Question 8. Market research demonstrates that individuals applying for a restricted possession and acquisition license, RPAL, in Ontario must provide accurate and complete information. Considering the legal framework governing firearms in Canada, which of the following approaches best ensures compliance with the requirements for obtaining an RPAL, particularly concerning past incidents that may impact public safety? Option A. Only disclose past domestic disputes if the application form explicitly asks about them and if charges were laid. Option B. Wait to be prompted by the licensing authority for specific details about past incidents before providing any information. Option C. Fully disclose all past incidents involving law enforcement or medical intervention related to personal conduct or mental health, even if no charges were laid or formal diagnoses were made, to allow the Chief Firearms Officer to conduct a comprehensive assessment. Option D. Assume that any incident where no charges were laid is irrelevant and does not need to be disclosed on the RPAL application. Correct answer is C. Fully disclose all past incidents involving law enforcement or medical intervention related to personal conduct or mental health, even if no charges were laid or formal diagnoses were made, to allow the Chief Firearms Officer to conduct a comprehensive assessment. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the complexities of Canadian firearms law, specifically the Restricted Possession and Acquisition License, RPAL, requirements, while also considering the ethical implications of potentially misrepresenting information to obtain a license. The onus is on the applicant to provide truthful and complete information, and on the licensing authority to assess that information accurately. Failure to do so can have serious legal consequences for the applicant and undermine the integrity of the firearms licensing system in Ontario. Correct approach analysis. The best professional practice involves a complete and truthful disclosure of all relevant information during the application process, including any past incidents that might be pertinent to the assessment of public safety. This approach aligns directly with the requirements of the Firearms Act, Canada, and the Criminal Code of Canada, which mandate that applicants for an RPAL must be deemed to be trustworthy and not a danger to public safety. Specifically, the applicant must disclose any instances of family violence, domestic disputes, or mental health concerns that have led to intervention by law enforcement or medical professionals, as these can be indicators of risk. Providing this information upfront allows the Chief Firearms Officer, CFO, in Ontario to conduct a thorough assessment, including consulting with spouses, former spouses, or partners as required by law, to determine eligibility. This proactive transparency upholds the spirit and letter of Canadian firearms legislation, ensuring public safety is prioritized. Incorrect approaches analysis. One incorrect approach involves omitting any mention of a past domestic dispute that involved police intervention, even if no charges were laid. This is a regulatory failure because the Firearms Act requires disclosure of any circumstances that could be relevant to public safety, and police involvement in a domestic dispute, regardless of outcome, is a significant factor the CFO must consider. Ethically, it constitutes a misrepresentation of facts. Another incorrect approach is to only disclose the domestic dispute if specifically asked about it by the application form. While the form may not explicitly list every possible scenario, the general requirement to provide truthful and complete information means that significant events like police-involved domestic disputes should be proactively disclosed. Relying on the form's specificity to limit disclosure is a failure to meet the broader legal obligation. A further incorrect approach is to assume that because no charges were laid, the incident is irrelevant and does not need to be disclosed. The assessment for an RPAL is not solely based on criminal convictions. The CFO has a mandate to assess the applicant's overall suitability and risk to public safety, which includes considering any history of violence or concerning behavior, even if it did not result in a formal charge. This approach demonstrates a misunderstanding of the comprehensive nature of the licensing process. Professional reasoning. Professionals in this situation should adopt a framework of absolute transparency and proactive disclosure. When faced with any situation that might be construed as relevant to public safety or trustworthiness, the default professional decision-making process should be to disclose it. This involves carefully reviewing the application requirements, understanding the underlying legislative intent, which is public safety, and erring on the side of providing more information rather than less. If unsure about the relevance of an event, it is best practice to disclose it and allow the licensing authority to make the determination. This approach mitigates legal risk, upholds ethical standards, and contributes to the responsible administration of firearms licensing. Question 9. Benchmark analysis indicates that an individual in Ontario, Canada, holding a valid restricted possession and acquisition license, RPAL, is considering purchasing a firearm that is classified as prohibited under Canadian federal law. Which of the following actions represents the most prudent and legally compliant approach for this RPAL holder? Option A. Verify the firearms classification under Canadian federal law and research any specific federal authorizations or exemptions that permit RPAL holders in Ontario to lawfully acquire and possess such a firearm, consulting official government resources and potentially legal counsel if necessary. Option B. Rely on advice from experienced firearm enthusiasts in local gun clubs to determine the legality of acquiring the prohibited firearm. Option C. Proceed with the acquisition, assuming that a valid RPAL permits the possession of any firearm not explicitly banned within Ontario. Option D. Purchase the firearm, believing that its legality is determined solely by provincial regulations, and that federal prohibitions do not apply if it is not specifically listed as illegal in Ontario. The correct answer is A. Verify the firearms classification under Canadian federal law and research any specific federal authorizations or exemptions that permit RPAL holders in Ontario to lawfully acquire and possess such a firearm, consulting official government resources, and potentially legal counsel if necessary. Explanation. Scenario analysis. This scenario presents a professional challenge for a restricted possession and acquisition license, RPAL, holder in Ontario, Canada, who is considering acquiring a firearm that is prohibited in Canada. The challenge lies in navigating the complex legal framework surrounding prohibited firearms, ensuring compliance with the Firearms Act, Canada, and its associated regulations, and understanding the specific requirements for possession, which may involve authorizations to carry or transport. Misinterpreting or disregarding these regulations can lead to severe legal consequences, including criminal charges and the revocation of their RPAL. Careful judgment is required to distinguish between legally permissible actions and those that constitute an offense. Correct approach analysis. The best professional practice involves a thorough understanding of the legal status of the firearm in question within Canada and Ontario. This means verifying if the firearm is classified as prohibited, restricted, or non-restricted under Canadian federal law. If it is prohibited, the individual must determine if any specific exemptions or authorizations exist that would permit lawful possession by an RPAL holder in Ontario. This would typically involve consulting official government resources such as the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program website, relevant sections of the Criminal Code of Canada, and the Firearms Act, Canada, and potentially seeking advice from a qualified legal professional specializing in firearms law. This approach ensures adherence to the law by proactively identifying and complying with all applicable federal and provincial regulations regarding the acquisition and possession of firearms. Incorrect approaches analysis. One incorrect approach is to assume that simply holding a valid RPAL automatically permits the acquisition of any firearm. This fails to recognize that the RPAL is a license to acquire and possess restricted and prohibited firearms under specific conditions, not a blanket authorization for all firearms. Prohibited firearms, in particular, have stringent acquisition and possession restrictions, often requiring specific authorizations that go beyond a standard RPAL. Another incorrect approach is to rely on informal advice from other firearm owners or online forums without independently verifying the information with official sources. While peer advice can sometimes be helpful, it is not a substitute for understanding the precise legal requirements. Misinformation regarding firearm classifications or possession rules can lead to unintentional violations of the law. A third incorrect approach is to proceed with the acquisition based on the belief that a firearm is legal if it is not explicitly banned in Ontario, without considering federal prohibitions. Canadian firearms law is primarily federal, with provincial regulations often supplementing or specifying aspects of federal law. A firearm prohibited federally remains prohibited regardless of provincial sentiment, and possession without the necessary federal authorizations is an offense. Professional reasoning. Professionals in this situation should adopt a proactive and diligent approach to legal compliance. This involves 1. Identifying the specific firearm and its classification under Canadian federal law. 2. Consulting official government resources, RCMP Canadian Firearms Program, Criminal Code, Firearms Act, to understand the legal requirements for possession of that classification of firearm. 3. If the firearm is prohibited, researching any specific exemptions or authorizations that may apply to RPAL holders in Ontario. 4. If uncertainty remains, seeking advice from a qualified legal professional specializing in firearms law. This systematic process ensures that all legal obligations are met before any acquisition is made, thereby preventing potential legal repercussions. Question 10. Benchmark analysis indicates that a licensed firearms dealer in Ontario holding an RPAL is selling a restricted firearm for $800. The sale includes a mandatory scope valued at $150 and a mandatory gun lock valued at $25. What is the correct amount of goods and services tax, GST, the dealer must collect and remit to the Canada Revenue Agency, CRA, for this transaction, assuming the current federal GST rate is 5%? Option A, $42.50, Option B, $40.00, Option C, $41.25, Option D, $47.50. The correct answer is D, $47.50. Explanation. Scenario analysis. This scenario presents a professional challenge for a restricted possession and acquisition license, RPAL holder in Ontario, Canada, who is also a licensed firearms dealer. The challenge lies in accurately calculating and remitting the goods and services tax (GST) on the sale of a restricted firearm, ensuring compliance with both federal tax legislation and provincial firearms regulations. Miscalculation or improper remittance can lead to significant financial penalties, loss of business license, and potential criminal charges under the Firearms Act. The complexity arises from understanding the taxable value of the firearm, including any accessories or services, and applying the correct GST rate. Correct approach analysis. The best professional practice involves accurately determining the total sale price of the restricted firearm, including any mandatory accessories or services bundled with the sale, and then applying the current federal GST rate of 5% to this total. This approach ensures that the tax is calculated on the full value of the transaction as defined by the Excise Tax Act. The calculated GST amount must then be remitted to the Canada Revenue Agency (CRA) within the prescribed timeframe. This method directly adheres to the principles of accurate tax collection and remittance as mandated by federal tax law, which is paramount for any licensed dealer operating in Ontario. Incorrect approaches analysis. One incorrect approach is to calculate the GST solely on the base price of the firearm, excluding the value of any included accessories or mandatory services. This fails to comply with the Excise Tax Act, which defines the price, for tax purposes, to include all charges for goods and services provided as part of the sale. This omission would result in underremittance of GST, leading to penalties and interest from the CRA. Another incorrect approach is to apply a provincial sales tax rate instead of the federal GST rate. Ontario does not have a provincial sales tax on firearms. Only the federal GST applies. Using an incorrect tax rate is a direct violation of federal tax legislation and demonstrates a fundamental misunderstanding of the applicable tax framework. A third incorrect approach is to assume that restricted firearms are exempt from GST. While certain goods and services may be exempt, restricted firearms sold by licensed dealers are generally subject to GST. Failing to collect and remit GST on taxable sales is a serious contravention of the Excise Tax Act and can result in severe penalties. Professional reasoning. Professionals in this situation must adopt a systematic approach. First, they must identify the specific item being sold and determine its tax status under the Excise Tax Act. Second, they must ascertain the total taxable value of the sale, including all components and services. Third, they must apply the correct tax rate as stipulated by federal legislation. Finally, they must ensure timely and accurate remittance of the collected tax to the appropriate government agency. This structured process, grounded in a thorough understanding of both firearms legislation and tax law, is essential for maintaining compliance and professional integrity. Question 11. Strategic planning requires an individual in Ontario applying for a restricted possession and acquisition license, RPAL, to acquire a restricted firearm. Before finalizing the purchase, what is the most critical step to ensure full compliance with the Canadian Firearms Act and its regulations? Option A. Assuming that standard home security measures are adequate for storing the restricted firearm. Option B. Confirming the applicant has a secure storage plan that meets all legal requirements for restricted firearms in Ontario and understands the regulations for transporting the firearm from the point of sale to its storage location. Option C. Proceeding with the purchase and addressing storage and transportation logistics after taking possession of the firearm. Option D. Prioritizing the acquisition of the firearm over understanding the specific legal requirements for its immediate transport and storage. Correct answer is B. Confirming the applicant has a secure storage plan that meets all legal requirements for restricted firearms in Ontario and understands the regulations for transporting the firearm from the point of sale to its storage location. Explanation. Strategic planning requires a thorough understanding of the Canadian Firearms Act and its associated regulations concerning restricted possession and acquisition licenses, RPAL. This scenario is professionally challenging because it involves navigating the legal requirements for acquiring a restricted firearm while ensuring compliance with all federal and provincial regulations, specifically those pertaining to the storage and transportation of restricted firearms in Ontario. Misinterpreting or overlooking any aspect of these regulations can lead to severe legal consequences, including license revocation and criminal charges. The best professional practice involves meticulously adhering to the legal framework for acquiring and possessing restricted firearms. This includes ensuring all necessary documentation is in order, such as a valid RPAL, and that the intended acquisition aligns with the conditions of that license. Crucially, it necessitates a proactive approach to understanding and implementing the stringent storage and transportation requirements mandated by the Firearms Act and its regulations in Ontario. This means confirming that the applicant has a secure storage plan in place that meets all legal specifications before the firearm is acquired, and understanding the specific rules for transporting it from the point of sale to the secure storage location. This approach prioritizes safety, legality, and responsible firearm ownership, directly aligning with the objectives of the Canadian Firearms Program. An incorrect approach would be to proceed with the acquisition without first confirming the applicant's readiness to meet storage and transportation requirements. This demonstrates a failure to fully consider the legal obligations that accompany the possession of a restricted firearm. It bypasses the critical step of ensuring safe and lawful storage from the outset, potentially leading to immediate noncompliance upon taking possession of the firearm. This approach neglects the fundamental principle of responsible firearm ownership and the legal onus placed on the license holder. Another incorrect approach is to assume that standard household security measures are sufficient for storing a restricted firearm. The Firearms Act and its regulations in Ontario specify detailed requirements for firearm storage, including the use of approved locking devices and the separation of ammunition. Relying on assumptions rather than verifying compliance with these specific legal mandates is a significant regulatory failure. Finally, an incorrect approach would be to prioritize the acquisition of the firearm over understanding the legalities of its immediate transport and storage. This suggests a lack of due diligence and a disregard for the safety and legal implications involved. The process of acquiring a restricted firearm is not merely a transaction. It is the commencement of a legal responsibility that includes immediate adherence to all storage and transportation laws. Professionals should employ a decision-making framework that begins with a comprehensive review of the relevant legislation and regulations. This should be followed by a thorough assessment of the applicant's understanding and preparedness to meet all legal obligations, particularly concerning storage and transportation. A proactive, information-gathering approach, prioritizing legal compliance and safety, is essential in all firearm acquisition scenarios. Question 12. The performance metrics show a significant increase in the average processing time for restricted possession and acquisition license, RPAL, applications submitted in Ontario over the past fiscal year. Considering the regulatory framework governing firearms in Canada, which of the following actions best addresses this performance issue while upholding legal and ethical obligations? Option A. Conduct a detailed audit of the entire RPAL application processing workflow to identify specific bottlenecks and areas for procedural improvement, and implement targeted solutions based on this analysis. Option B. Implement a new, more stringent set of interview questions for all RPAL applicants to ensure a higher level of vetting, regardless of previous application history. Option C. Reduce the scope and depth of reference checks for all RPAL applicants to expedite the background investigation phase. Option D. Impose a temporary moratorium on all new RPAL applications until the backlog is cleared, citing public safety concerns due to processing delays. The correct answer is A. Conduct a detailed audit of the entire RPAL application processing workflow to identify specific bottlenecks and areas for procedural improvement, and implement targeted solutions based on this analysis. Explanation. The performance metrics show a concerning trend in the processing times for restricted possession and acquisition license, RPAL, applications in Ontario. This scenario is professionally challenging because delays in processing can have significant real-world consequences for law-abiding citizens who wish to acquire firearms for legitimate purposes, such as sport shooting or hunting. It also raises questions about the efficiency and effectiveness of the regulatory oversight body responsible for these applications. Careful judgment is required to identify the root cause of the delays and propose appropriate solutions that align with the Firearms Act Canada and its associated regulations, while also ensuring public safety. The best approach involves a thorough, data-driven analysis of the application workflow, identifying specific bottlenecks and areas of inefficiency. This would include examining the stages from initial submission, background checks, reference checks, and final approval. By pinpointing where delays are occurring, targeted improvements can be implemented, such as streamlining administrative processes, increasing staffing in critical areas, or leveraging technology for faster information verification. This approach is correct because it directly addresses the observed performance issue with a systematic and evidence-based methodology, ensuring that any proposed solutions are practical, effective, and compliant with the spirit and letter of Canadian firearms legislation, which prioritizes both public safety and the rights of licensed individuals. An incorrect approach would be to implement a blanket policy of stricter scrutiny on all applications, regardless of individual circumstances, in an attempt to catch up on processing times. This is ethically and regulatorily flawed because it punishes all applicants for systemic issues and could lead to unjustified delays and denials, potentially violating the principles of fairness and due process. Another incorrect approach would be to reduce the thoroughness of background checks to expedite processing. This is a critical regulatory failure, as the integrity of these checks is paramount to public safety and a core requirement of the Firearms Act. Finally, simply increasing the application fee without a clear plan for improving efficiency would be an unacceptable approach, as it places an undue financial burden on applicants without addressing the underlying performance problem, and could be seen as a form of profiteering from regulatory inefficiency. Professionals should approach such situations by first gathering comprehensive data on the performance issue. This data should then be analyzed to identify specific causes. Solutions should be developed collaboratively, involving stakeholders where appropriate, and must be grounded in regulatory compliance and ethical considerations. A continuous improvement mindset, involving regular monitoring and evaluation of implemented changes, is essential for sustained effectiveness. Question 13. Stakeholder feedback indicates that a firearms safety course instructor in Ontario, Canada, is conducting a mandatory course for individuals seeking a restricted possession and acquisition license, RPAL. During the course, an applicant mentions their strong interest in acquiring a specific type of firearm that, based on the instructor's knowledge, might fall under prohibited classifications due to its characteristics. What is the most appropriate professional course of action for the instructor in this situation, adhering strictly to Canadian firearms legislation and provincial training standards? Option A. Immediately refuse to continue the course for this applicant, informing them that their stated interest suggests they are not eligible for an RPAL and therefore cannot legally possess firearms. Option B. Offer advice on how the applicant might modify the firearm in question to potentially make it legal for RPAL holders, without consulting official legal interpretations or the RCMP. Option C. Proceed with the course as scheduled, assuming the applicant will independently research and ensure the legality of any firearm they eventually decide to purchase. Option D. Clearly explain the legal definitions of restricted and prohibited firearms under Canadian law, detailing the criteria that might classify the applicant's firearm of interest as prohibited, and advise the applicant to verify the legal status of any intended acquisition with official sources before proceeding. The correct answer is D. Clearly explain the legal definitions of restricted and prohibited firearms under Canadian law, detailing the criteria that might classify the applicant's firearm of interest as prohibited, and advise the applicant to verify the legal status of any intended acquisition with official sources before proceeding. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms safety course instructor in Ontario, Canada, who is tasked with verifying the eligibility of an applicant for a restricted possession and acquisition license, RPAL. The challenge lies in balancing the need to adhere strictly to the Firearms Act, Canada, and its associated regulations, particularly concerning the definition of prohibited firearm, and the applicant's declared intent, with the instructor's duty to provide accurate safety training and not to prejudge an applicant's eligibility. Misinterpreting the applicant's stated interest in a firearm that could be classified as prohibited, or failing to properly guide them on the legal distinctions, could lead to the applicant making an illegal acquisition or the instructor providing misleading information, both of which have serious legal and ethical ramifications. Correct approach analysis. The best professional practice involves clearly and accurately educating the applicant on the legal classifications of firearms in Canada, specifically distinguishing between restricted and prohibited firearms, and explaining the conditions under which certain firearms might be prohibited. This approach requires the instructor to explain the relevant sections of the Firearms Act, Canada, and the Criminal Code of Canada that define prohibited firearms and the circumstances of their prohibition, e.g., based on barrel length, caliber, or specific model designations. The instructor should then guide the applicant to understand that, while they can learn about firearm safety, the acquisition of a prohibited firearm is illegal, and they must ensure any firearm they intend to acquire is legally permissible for an RPAL holder. This aligns with the instructor's obligation to impart accurate knowledge of firearms law and safety, as mandated by the Canadian Firearms Program and provincial training standards, ensuring the applicant understands their legal responsibilities before proceeding with any acquisition. Incorrect approaches analysis. One incorrect approach involves dismissing the applicant's interest outright and refusing to proceed with the course based solely on the mention of a firearm that might be prohibited. This is professionally unacceptable because it constitutes prejudgment of the applicant's eligibility and fails to provide them with the necessary education about firearm classifications. The instructor's role is to educate on safety and legality, not to act as a licensing authority or to deny training based on a potentially misunderstood statement. Another incorrect approach is to proceed with the course without clarifying the legal status of the firearm mentioned, assuming the applicant will sort out the legality themselves. This is ethically and legally flawed as it neglects the instructor's duty to ensure the applicant is fully informed about the laws governing firearm possession and acquisition in Ontario. It risks facilitating an illegal acquisition by omission of critical information. A third incorrect approach is to advise the applicant on how to circumvent the regulations or to suggest modifications to the firearm that would make it legal without proper legal counsel or understanding of the specific firearm's classification. This is highly unprofessional and potentially illegal, as it could be construed as aiding or abetting an illegal act and goes beyond the scope of a firearms safety instructor's mandate. Professional reasoning. Professionals in this role must adopt a framework of education and legal compliance. When faced with ambiguity or potentially problematic statements from an applicant, the primary responsibility is to educate them on the relevant laws and regulations. This involves clearly explaining legal definitions, prohibitions, and the process for legal acquisition. If an applicant expresses interest in a firearm that raises red flags regarding its classification, the instructor should explain the legal distinctions and advise the applicant to consult official resources or the relevant authorities, like the RCMP Canadian Firearms Program, to confirm the legal status before proceeding with any acquisition. The instructor's role is to empower the applicant with knowledge, not to make decisions for them or to facilitate potentially illegal actions. Question 14. Regulatory review indicates an individual in Ontario is applying for a restricted possession and acquisition license, RPAL, and has had a minor interaction with law enforcement in the past that was resolved without charges. The applicant is unsure if this interaction needs to be disclosed on the application form, as they believe it was insignificant. What is the most appropriate course of action for the applicant to ensure compliance with Canadian firearms regulations? Option A. Rely on informal advice from a friend who also owns firearms regarding whether the interaction needs to be disclosed. Option B. Omit the past interaction from the RPAL application, assuming that minor, unresolved incidents do not require disclosure. Option C. Misrepresent the nature of the past interaction on the RPAL application to emphasize its minor status. Option D. Fully disclose the past interaction with law enforcement on the RPAL application, providing all relevant details, and allow the Registrar of Firearms to assess its significance. The correct answer is D. Fully disclose the past interaction with law enforcement on the RPAL application, providing all relevant details, and allow the Registrar of Firearms to assess its significance. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the complex requirements of the Canadian Firearms Act, specifically concerning the Restricted Possession and Acquisition License, RPAL, while also considering the ethical implications of potentially misrepresenting information. The applicant's desire to acquire a firearm for a specific purpose, coupled with a past incident that might impact their eligibility, necessitates a thorough and honest approach to the application process. Failure to do so could result in severe legal consequences and a loss of trust in the firearms community. Correct approach analysis. The best professional practice involves the applicant fully disclosing all relevant information on the RPAL application, including any past interactions with law enforcement, regardless of whether they believe it directly impacts their eligibility. This approach aligns with the fundamental principle of honesty and transparency required by the Firearms Act and its associated regulations in Canada. Specifically, the application form requires disclosure of any arrests, charges, or convictions, and it is the applicant's responsibility to provide accurate and complete information. The Registrar of Firearms will then assess the information provided in the context of the eligibility criteria outlined in the Act, such as the applicant's suitability to possess firearms and the absence of any prohibitive circumstances. This ensures that the licensing authority has all necessary information to make an informed decision, upholding public safety and the integrity of the firearms licensing system in Canada. Incorrect approaches analysis. Providing incomplete information by omitting the detail about the past interaction with law enforcement, even if the applicant believes it was minor or resolved, is a direct contravention of the requirement for full disclosure on the RPAL application. This failure to be truthful can lead to the denial of the license, and if discovered after issuance, can result in the revocation of the license and potential criminal charges for making a false statement. Attempting to downplay or mischaracterize the past interaction with law enforcement on the application is also a serious ethical and regulatory failure. This constitutes providing misleading information, which undermines the integrity of the application process and the authority of the registrar. Such an action demonstrates a lack of good faith and a disregard for the legal obligations associated with obtaining an RPAL in Canada. Seeking advice from an unqualified individual or relying on informal opinions about the necessity of disclosure, rather than consulting the official application guidelines or directly contacting the Canadian Firearms Program, is professionally unsound. This can lead to misinterpretations of the law and regulations, resulting in an incomplete or inaccurate application and potentially jeopardizing the applicant's eligibility. Professional reasoning. Professionals in this situation should adopt a framework of absolute transparency and adherence to official guidelines. This involves 1. Understanding the legal obligations. Familiarize oneself with the specific requirements of the Canadian Firearms Act and the RPAL application process. 2. Full disclosure. Provide all requested information accurately and completely, even if it seems minor or potentially disadvantageous. 3. Seeking clarification. If unsure about any aspect of the application or disclosure requirements, contact the official Canadian Firearms Program directly for guidance. 4. Honesty and integrity. Recognize that the application process is a legal requirement designed to ensure public safety, and any attempt to circumvent or mislead the process is unethical and illegal. Question 15. Performance analysis shows that a firearms instructor in Ontario, Canada, is advising a client who wishes to obtain a restricted possession and acquisition license, RPAL. The client is eager to start the process quickly. What is the most appropriate course of action for the instructor to ensure compliance with Canadian firearms laws and best professional practices? Option A. Advise the client that they can begin the application process while simultaneously enrolling in the required safety courses, as this will expedite the overall timeline. Option B. Thoroughly explain all mandatory requirements for the RPAL, including the necessity of completing both the Canadian Firearms Safety Course, CFSC, and the Canadian Restricted Firearms Safety Course, CRFSC, the background check process, the role of references, and the ongoing responsibilities of license holders, guiding the client through each step accurately. Option C. Inform the client that the reference checks are a minor part of the application and can be completed by any close friends or family members, regardless of their ability to speak to the applicant's suitability for firearm ownership. Option D. Provide a simplified overview of the RPAL process, highlighting the CFSC as the primary training and mentioning that the restricted component can be addressed later, encouraging the client to start the application paperwork immediately. The correct answer is B. Thoroughly explain all mandatory requirements for the RPAL, including the necessity of completing both the Canadian Firearms Safety Course, CFSC, and the Canadian Restricted Firearms Safety Course, CRFSC, the background check process, the role of references, and the ongoing responsibilities of license holders, guiding the client through each step accurately. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms instructor in Ontario, Canada, who is tasked with advising a client on the Restricted Possession and Acquisition License (RPAL) process. The challenge lies in balancing the client's enthusiasm with the strict legal requirements and safety obligations mandated by the Firearms Act, Canada, and its associated regulations. Misinterpreting or misrepresenting these requirements can lead to serious legal consequences for both the applicant and the instructor, including potential charges and revocation of licenses. The instructor must ensure the client understands the full scope of responsibilities and the rigorous application process. Correct approach analysis. The best professional practice involves a comprehensive and accurate explanation of the RPAL application process, emphasizing all legal prerequisites and safety training requirements as stipulated by the Firearms Act, Canada. This includes detailing the mandatory Canadian Firearms Safety Course, CFSC, and the Canadian Restricted Firearms Safety Course, CRFSC, the background checks, the requirement for references, and the ongoing obligations of a license holder. This approach is correct because it directly aligns with the instructor's duty of care and the legal framework governing firearms in Ontario, ensuring the client is fully informed and prepared to meet all statutory obligations. Adhering strictly to the regulations protects the public and upholds the integrity of the firearms licensing system. Correct approaches analysis. Providing a simplified overview that omits the mandatory CRFSC and focuses solely on the CFSC is a significant regulatory failure. The CRFSC is a specific, legally mandated component for obtaining an RPAL, and its omission misleads the applicant about the full training requirements. This approach fails to meet the instructor's obligation to provide accurate information as per the Firearms Act, suggesting that the client can begin the application process before completing both the CFSC and CRFSC is a direct contravention of the licensing requirements. Regulations clearly state that successful completion of these courses is a prerequisite for application. This approach demonstrates a lack of understanding of the statutory order of operations and could lead to the application being rejected, wasting the applicant's time and resources, and potentially implicating the instructor for providing erroneous advice. Advising the client that the reference checks are merely a formality and can be completed by close friends without regard for their knowledge of the applicant's suitability to possess firearms is a serious ethical and regulatory lapse. The reference checks are a critical component of the background investigation, designed to assess the applicant's character and suitability. Failing to emphasize the importance of selecting references who can genuinely attest to the applicant's responsible behavior and lack of risk is a dereliction of duty and undermines the safety provisions of the Firearms Act. Professional reasoning. Professionals in this field must adopt a decision-making process rooted in a thorough understanding of the Firearms Act, Canada, and its regulations. This involves prioritizing accuracy, completeness, and adherence to all legal requirements. When advising clients, instructors should always err on the side of providing more comprehensive information rather than less. A structured approach would involve 1. Identifying the specific license type and its associated legal requirements. 2. Clearly outlining all mandatory training, documentation, and background checks. 3. Emphasizing the ongoing responsibilities and legal obligations of license holders. 4. Consulting official government resources and regulatory guidance to ensure advice is current and accurate. Any deviation from these principles risks regulatory noncompliance and ethical breaches. Question 16. Quality control measures reveal that an individual in Ontario holding a Restricted Possession and Acquisition License (RPAL) has stored their newly acquired restricted firearm. Considering the requirements of the Criminal Code of Canada and its associated regulations, which of the following storage methods demonstrates the highest level of compliance and professional responsibility? Option A. The restricted firearm is unloaded and secured with a trigger lock, and both the firearm and its ammunition are stored separately in a locked gun safe. Option B. The restricted firearm is unloaded and transported in a locked case in the trunk of a vehicle, with the ammunition stored in the glove compartment. Option C. The restricted firearm is unloaded and secured with a trigger lock, and both the firearm and its ammunition are stored together in a locked gun safe. Option D. The restricted firearm is unloaded and stored in a locked cabinet, but the ammunition is kept in a separate, unlocked drawer in the same room. The correct answer is A. The restricted firearm is unloaded and secured with a trigger lock, and both the firearm and its ammunition are stored separately in a locked gun safe. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the complexities of firearm ownership regulations in Canada, specifically concerning the Restricted Possession and Acquisition License, RPAL. The challenge lies in accurately interpreting and applying the Criminal Code of Canada and its associated regulations regarding the storage, transportation, and acquisition of restricted firearms. Misinterpreting these rules can lead to serious legal consequences, including the revocation of licenses and potential criminal charges. Careful judgment is required to ensure full compliance and public safety. Correct approach analysis. The best professional practice involves meticulously adhering to the storage requirements outlined in the storage, transportation, and handling of firearms regulations, which are part of the Criminal Code of Canada. This means ensuring that any restricted firearm is unloaded, locked with a trigger lock or cable lock, and stored separately from its ammunition. The firearm must also be stored in a locked container, such as a gun safe or a locked cabinet, that is not readily accessible to unauthorized individuals. This approach directly addresses the legal obligations for RPAL holders and prioritizes public safety by preventing unauthorized access to restricted firearms. Incorrect approaches analysis. One incorrect approach involves storing the restricted firearm unloaded, but with the ammunition stored in the same locked container. This fails to meet the regulatory requirement of storing the firearm and ammunition separately, creating a potential safety risk and violating the Criminal Code of Canada. Another incorrect approach is to store the restricted firearm with a trigger lock attached, but without it being placed in a separate locked container. While the trigger lock addresses one aspect of safe storage, the lack of a secondary locked container means the firearm is not secured against unauthorized access as mandated by the regulations, thus failing to meet the full requirements of the Criminal Code of Canada. A further incorrect approach is to transport the restricted firearm unlocked in the trunk of a vehicle, even if it is unloaded. Regulations explicitly require restricted firearms to be transported in a locked container and to be unloaded, often with the ammunition stored separately. Transporting it unlocked, even if unloaded, poses a significant safety risk and contravenes the Criminal Code of Canada. Professional reasoning. Professionals dealing with firearm regulations must adopt a proactive and diligent approach. This involves thoroughly understanding the specific legal requirements of the Criminal Code of Canada and its associated regulations. When in doubt, seeking clarification from the relevant authorities, such as the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program, is crucial. A commitment to continuous learning and strict adherence to all safety protocols is paramount to maintaining public trust and ensuring legal compliance. Question: Quality control measures reveal that an individual in Ontario holding a Restricted Possession and Acquisition License, RPAL, has stored their newly acquired restricted firearm. Considering the requirements of the Criminal Code of Canada and its associated regulations, which of the following storage methods demonstrates the highest level of compliance and professional responsibility? Options: A. The restricted firearm is unloaded and secured with a trigger lock, and both the firearm and its ammunition are stored separately in a locked gun safe. B. The restricted firearm is unloaded and secured with a trigger lock, and both the firearm and its ammunition are stored together in a locked gun safe. C. The restricted firearm is unloaded and stored in a locked cabinet, but the ammunition is kept in a separate, unlocked drawer in the same room. D. The restricted firearm is unloaded and transported in a locked case in the trunk of a vehicle, with the ammunition stored in the glove compartment. Question 17. The monitoring system demonstrates that a restricted firearm, legally possessed under a Restricted Possession and Acquisition License, RPAL, in Ontario, was observed in a locked container within the passenger compartment of a vehicle that was subsequently stopped by law enforcement. The license holder claims the firearm was unloaded and the container was locked, but the specific configuration of the container and its placement within the passenger area are unclear. What is the most appropriate course of action for the license holder in this immediate situation? Option A. Assert that the firearm was unloaded and the container was locked, and therefore compliance was met, and continue to the intended destination. Option B. Immediately contact the local police service or the Chief Firearms Officer for Ontario to report the situation and seek guidance on proper procedure. Option C. Assume the firearm is adequately secured due to the locked container and proceed with the original travel plans, only addressing the matter if directly questioned by law enforcement. Option D. Attempt to move the firearm to the trunk of the vehicle or a less conspicuous location within the passenger compartment to avoid further scrutiny. The correct answer is B. Immediately contact the local police service or the Chief Firearms Officer for Ontario to report the situation and seek guidance on proper procedure. Explanation: the monitoring system demonstrates a potential lapse in adherence to the Canadian Firearms Act, specifically concerning the storage and transportation requirements for restricted firearms in Ontario. This scenario is professionally challenging because it requires immediate and accurate assessment of a situation that could have significant legal and safety implications. The onus is on the license holder to ensure compliance, and a failure to do so can result in severe penalties, including license revocation and criminal charges. The best professional practice involves a proactive and thorough approach to verifying compliance with all applicable regulations. This means understanding that the presence of a restricted firearm in a vehicle, even if seemingly secured, necessitates strict adherence to the storage and transportation provisions outlined in the storage, display, transportation, and handling of firearms regulations. The correct approach is to immediately cease operation of the vehicle and contact the appropriate authorities, such as the local police service or the Chief Firearms Officer for Ontario. Report the situation and seek guidance on how to proceed in a manner that ensures public safety and legal compliance. This demonstrates a commitment to responsible firearm ownership and a willingness to rectify any potential noncompliance. An incorrect approach would be to assume that the firearm is adequately secured simply because it is in a locked container within the vehicle. This overlooks the specific requirements for transportation of restricted firearms in Canada, which often mandate that the firearm be unloaded, the action be open, and it be separated from ammunition, and that the container itself be specifically designed for firearm transport and not readily accessible from the vehicle's passenger compartment. Another incorrect approach would be to continue driving to the intended destination, believing that the firearm is secure enough for the short duration of the trip. This disregards the strict liability nature of many firearms regulations and the potential for unforeseen circumstances during transit. Finally, attempting to conceal the firearm further or move it to a less conspicuous location within the vehicle without proper authorization or understanding of the regulations would also be an unacceptable and potentially illegal action. Professionals facing similar situations should employ a decision-making framework that prioritizes safety and legal compliance above all else. This involves 1. Recognizing the potential for regulatory noncompliance. 2. Immediately halting any activity that could exacerbate the situation. 3. Consulting the relevant legislation and regulations, in this case, the Canadian Firearms Act and its associated regulations for Ontario. 4. Seeking expert advice from law enforcement or the Chief Firearms Officer when in doubt. 5. Acting decisively and transparently to rectify the situation in accordance with legal requirements. Question 18. Benchmark analysis indicates that an individual holding a restricted possession and acquisition license, RPAL, in Ontario is interested in acquiring a firearm classified as prohibited under Canadian federal law. The seller, also a licensed individual, claims the firearm is legal to acquire. What is the most prudent and legally compliant course of action for the RPAL holder to take? Option A. Proceed with the acquisition based on the seller's verbal assurance that the firearm is legal to own, trusting their license status. Option B. Assume the acquisition is legal because the seller possesses a firearms license and address any registration issues after taking possession. Option C. Acquire the firearm and then attempt to register it, hoping the authorities will approve the transaction. Option D. Verify the specific legal status and acquisition eligibility of the prohibited firearm under Canadian federal law and Ontario regulations, ensuring all necessary authorizations and transfer procedures are met before proceeding with the acquisition. The correct answer is D. Verify the specific legal status and acquisition eligibility of the prohibited firearm under Canadian federal law and Ontario regulations, ensuring all necessary authorizations and transfer procedures are met before proceeding with the acquisition. Explanation: Scenario analysis. This scenario presents a professional challenge for a restricted possession and acquisition license (RPAL) holder in Ontario who is considering acquiring a prohibited firearm. The core difficulty lies in navigating the complex and stringent regulations surrounding prohibited firearms, which have specific acquisition pathways and require strict adherence to legal requirements. Failure to do so can result in severe legal penalties, including criminal charges and the revocation of their RPAL. Careful judgment is required to ensure any acquisition is fully compliant with the Firearms Act and its associated regulations. Correct approach analysis. The best professional practice involves meticulously verifying the specific legal status and acquisition eligibility of the firearm in question under Ontario and Canadian federal law. This means confirming if the firearm is a grandfathered prohibited firearm that can be lawfully acquired by an RPAL holder, and if so, understanding the precise transfer requirements, such as the need for a specific authorization to acquire and the registration process. This approach is correct because it prioritizes full compliance with the Firearms Act, Canada, and the Criminal Code of Canada, which are the governing statutes for firearm possession and acquisition. It ensures that the RPAL holder acts within the legal framework, preventing any potential contravention of the law. Incorrect approach is analysis. One incorrect approach involves proceeding with the acquisition based on a verbal assurance from the seller that it is legal to own. This is professionally unacceptable, because it relies on hearsay rather than verifiable legal documentation and regulatory compliance. The onus is on the buyer to ensure the legality of the acquisition, and verbal assurances do not absolve them of this responsibility under the Firearms Act. Another incorrect approach is assuming that because the seller is a licensed individual, the transaction is automatically legal. While licensed individuals must operate within the law, their license does not grant them the authority to circumvent specific regulations pertaining to prohibited firearms. The acquisition of prohibited firearms is subject to distinct rules beyond general licensing. A further incorrect approach is to acquire the firearm and then attempt to register it, hoping it will be accepted. This demonstrates a fundamental misunderstanding of the acquisition process for prohibited firearms. Registration is a consequence of a lawful acquisition, not a mechanism to legitimize an otherwise illegal transaction. Attempting to register a firearm that cannot be legally acquired by the individual is a serious regulatory failure. Professional reasoning. Professionals in this situation should always adopt a proactive and diligent approach to legal compliance. This involves 1. Thoroughly researching the specific classification of the firearm under Canadian federal law and any relevant provincial regulations in Ontario. 2. Consulting official sources such as the Canadian Firearms Program website, or directly contacting the Chief Firearms Officer for Ontario for clarification on acquisition eligibility and procedures for prohibited firearms. 3. Obtaining all necessary documentation and authorizations before taking possession of the firearm. 4. Understanding that the responsibility for legal acquisition rests solely with the RPAL holder. Question 19. Benchmark analysis indicates that an individual in Ontario holding a restricted possession and acquisition license, RPAL, has recently acquired a firearm that they now suspect is a prohibited firearm under Canadian federal law. The individual has not yet reported this acquisition to the authorities. What is the most appropriate and legally compliant course of action for this RPAL holder? Option A. Attempt to sell or transfer the firearm to another licensed individual to avoid potential legal complications. Option B. Store the firearm securely and await further instructions or information before taking any action. Option C. Immediately contact the local police service or the RCMP Canadian Firearms Program to report the acquisition and seek guidance on the legal disposition of the firearm. Option D. Dismantle the firearm into its component parts and store them separately to avoid immediate legal scrutiny. The correct answer is C. Immediately contact the local police service or the RCMP Canadian Firearms Program to report the acquisition and seek guidance on the legal disposition of the firearm. Explanation. Scenario analysis. This scenario presents a professional challenge for a restricted possession and acquisition license, RPAL, holder in Ontario who has acquired a prohibited firearm. The challenge lies in navigating the legal requirements for possessing such an item, which is strictly regulated under Canadian federal law, specifically the Firearms Act and its associated regulations, as well as provincial legislation in Ontario that may impose additional requirements or enforcement mechanisms. Failure to comply can result in severe legal penalties, including criminal charges and the revocation of their RPAL. Careful judgment is required to ensure immediate and correct action is taken to avoid contravening the law. Correct approach analysis. The best professional practice involves immediately contacting the local police service or the Royal Canadian Mounted Police (RCMP) Canadian Firearms Program to report the acquisition of the prohibited firearm and to seek guidance on the legal disposition of the item. This approach is correct because it demonstrates proactive compliance with federal firearms legislation, specifically the requirements for reporting and managing prohibited firearms. The Firearms Act mandates that individuals must comply with regulations concerning the possession of prohibited firearms, which often involve specific registration, authorization, or surrender procedures. By contacting the authorities, the individual initiates the legal process for dealing with the prohibited firearm in a manner that aligns with the law, such as obtaining the necessary authorizations if applicable, or arranging for its safe surrender and disposal. This proactive step mitigates the risk of illegal possession and demonstrates due diligence. Incorrect approaches analysis. One incorrect approach is to store the prohibited firearm without reporting it, intending to address the situation later. This is a regulatory failure because it constitutes illegal possession of a prohibited firearm under the Firearms Act. The law does not permit the unlicensed or unauthorized possession of such items, even if the intention is to rectify the situation at a later date. Another incorrect approach is to attempt to sell or transfer the prohibited firearm to another individual without proper authorization. This is a significant regulatory and ethical failure, as it facilitates the illegal transfer of a prohibited weapon, potentially putting others at risk and violating numerous provisions of the Firearms Act related to transfers and authorizations. It also exposes the individual to severe criminal liability. A third incorrect approach is to dismantle the prohibited firearm and store its components separately, believing this circumvents the law. This is a flawed understanding of the law, as prohibited firearms remain prohibited regardless of their assembled state, and possession of the components with the intent to reassemble or possess a prohibited firearm can still lead to charges. Professional reasoning. Professionals in possession of firearms, especially those who acquire items that may be prohibited, must prioritize immediate and transparent communication with the relevant authorities. The decision-making process should involve a thorough understanding of the Firearms Act and its regulations. When in doubt about the classification of a firearm or the legality of its possession, the safest and most legally sound action is to seek official guidance from the police or the RCMP Canadian Firearms Program. This ensures that any actions taken are in full compliance with the law, protecting both the individual and public safety. Question 20. The assessment process reveals that a Canadian resident holding a valid restricted possession and acquisition license, RPAL, issued on March 15, 2023, wishes to acquire their fifth restricted firearm. If today's date is October 20, 2023, and they have already acquired 4 restricted firearms on April 10, 2023, May 15, 2023, June 20, 2023, and July 25, 2023, what is the maximum number of restricted firearms they are legally permitted to acquire on October 20, 2023, according to the Firearms Act, Canada? Option A, 0, as they have already acquired 4 firearms and the next acquisition would exceed the limit for the current 30-day period. Option B, 1, as they have completed 5 30-day acquisition periods since their license was issued. Option C, 2, as they have completed more than 4 30-day acquisition periods and can acquire 2 more. Option D, 4, as they have already acquired 4 and can acquire 1 more within the current 30-day period. The correct answer is B, 1, as they have completed 5 30-day acquisition periods since their license was issued. Explanation. The assessment process reveals a scenario that is professionally challenging due to the need for precise calculation and adherence to specific legislative requirements for firearm acquisition in Canada. Misinterpreting or miscalculating the number of firearms an individual can acquire within a given time frame, based on their restricted possession and acquisition license, RPAL, can lead to serious contraventions of the Firearms Act and its associated regulations. This requires a meticulous approach to record keeping and understanding the limitations imposed by the license. The correct approach involves accurately calculating the number of restricted firearms an individual can acquire based on the license's validity period, and any previously acquired firearms within that period. This is achieved by understanding that an RPAL holder can acquire one restricted firearm every 30 days, starting from the date of their license issuance, unless specific exemptions apply. The calculation must account for the license's start date and the current date to determine the number of 30-day periods that have elapsed. For example, if a license was issued on January 1, 2023, by July 1, 2023, 6 30-day periods would have passed, allowing for the acquisition of up to 6 restricted firearms. This method directly aligns with the spirit and letter of the Canadian Firearms Act, which aims to regulate the acquisition of restricted firearms to ensure public safety and prevent undue accumulation. An incorrect approach would be to simply count the number of years the license has been valid and multiply by 12, assuming one firearm per month, without considering the 30-day waiting period between acquisitions. This fails to acknowledge the specific regulatory requirement of a 30-day interval between acquisitions, potentially leading to an illegal acquisition. Another incorrect approach would be to assume the license allows for the acquisition of a set number of firearms per year, such as 12, without any regard for the 30-day rule or the license's actual start date. This is a gross misinterpretation of the acquisition limits. Finally, an approach that ignores the license's start date and only considers the current date to calculate elapsed time would be flawed, as the 30-day periods must be measured from the license issuance. The professional decision-making process for such situations requires a thorough understanding of the Firearms Act, Canada, and its regulations, specifically concerning the acquisition of restricted firearms. Professionals must prioritize accuracy in calculation, cross-referencing license details with the current date and the 30-day acquisition rule. When in doubt, consulting official RCMP Canadian Firearms Program resources or legal counsel specializing in firearms law is paramount to ensure compliance and uphold ethical responsibilities.